Okay, let's talk next about House Bill 2106. This bill is related to the bill, this prior bill that we just talked about, 1498, where we had to have that language that has to go in violation notices pertaining to the condition of the property. This bill is related to that. They didn't put it together, but this bill is related to it. And basically the impact of this bill is that if we send an owner a letter regarding a violation on the condition of their property, the grace period for them to be able to respond has been extended from 10 business days to 21 calendar days. So let's give an example. Let's say that we decide to send Johnny Appleseed a letter because he has made an exterior modification to his home without getting approval of the architectural committee. And we send him a demand letter regarding the condition of his property, violation. We cannot take the next step, meaning turn it over to the attorney, fine him, take any legal action such as file a lawsuit until that 21 calendar day period has expired. That's what the law says. Now there's a loophole, there's an exception. What the law says is that if the owner responds back to the association by certified mail, it's just this weird law, we are required to provide 5 categories of information to the owner. And then once we provide those 5 categories of information, then bam, we can go ahead and take the next step. Fine, turn it over to our attorney, file a lawsuit, whatever. So the 5 areas of information are, number 1, we have to provide the provision in the CC&Rs that's being violated. So that's easy. 2, the date the violation was observed or the actual date of the violation. 3, the first and last name of the person or person who observed the violation. 4, the process the unit owner must follow to contest the notice. And 5, the statement that we just talked about 5 minutes ago, that you can petition for an administrative hearing with the Arizona Department of Real Estate. So what's the way around this law? Okay, there's 2 ways you can do it. When you send a notice of violation regarding the condition of the property, you can just send out a notice that doesn't have these 5 categories of information. Okay, if you do it that way, you have to wait 21 days. Okay, before you can take the next action. And if within that 21-day period, they send you a certified letter, that's the trigger. You get a certified letter from the homeowner, then bam, you have to provide these 5 categories of information. The way around it, so that's one way to do it. Send the letter, wait 21 days, see if they send us a certified letter. If they do, we provide the 5 categories of information. That's one way. The other way is to just put the 5 categories of information in your first letter. And then you can move forward right away. You don't even have to wait 21 days. And so think about that, especially for violations like RV parking. Because people can play games if you're doing the 21-day thing. They can park the RV in such a way that they're never going to get fined because they know that we have to wait 21 days before we can, take action on something. So be strategic in how you use that. Best practices from my standpoint would be just put these 5 categories of information in every violation letter you send regarding the condition of the property. And then you don't even have to worry about certified mail, waiting days. You've already complied with the law. You don't have to wait at all.